All right, welcome to Talk Testimonies, everyone. We're back with another deep dive, and this time we're tackling a Supreme Court case that really gets to the heart of how our elections work and, well, maybe sometimes don't work.
Absolutely. And, we love to dissect these complex Supreme Court arguments, but today's case is especially fascinating because it deals with an issue that honestly affects all of us, the way our voting districts are drawn.
Exactly. It's all about the maps, those lines that divide our states and sometimes our communities into different voting districts. And in this particular case, Lomone v. Benisek, we see how those lines can become incredibly controversial, especially when accusations of partisan gerrymandering start flying around.
Right. And I think a lot of people have heard that term gerrymandering, but it can get pretty confusing trying to understand exactly what it means and when it crosses that line into being unconstitutional.
Yeah.
So that's where we come in, ready to break it all down for you.
Yeah. Think of us as your Supreme Court whisperers, cutting through all the legal jargon and focusing on the core ideas and arguments in this case. So where should we start?
Well, how about with a little background on Lomone v. Benisek?
Sounds good to me. Let's set the stage.
All right, so this case revolved around a challenge to Maryland's congressional redistricting map, specifically the one they adopted back in 2011. The plaintiffs, the folks bringing the lawsuit, were a group of registered voters in Maryland, including a gentleman named Stephen Benisek. Their main grievance was with the way the Sixth Congressional District had been redrawn.
And their argument was that this redrawing was done with a very specific purpose, to intentionally dilute the voting power of Republican voters in that district and give Democrats a significant advantage. They claimed that this was a clear violation of their First Amendment rights, basically arguing that they were being punished for their political beliefs through this manipulation of the electoral map. Okay, so right from the start, we see this clash between partisan politics and fundamental rights. And it gets even more interesting when we look at who was on the other side of this legal battle. That would be Linda Lomone, the administrator of elections for the state of Maryland.
Right, Lomone was essentially representing the state and defending the redistricting plan. Their main line of defense rested on a couple of key ideas.
I'll lay it on us.
Okay, first, they argued that when it comes to drawing political maps, some degree of partisan consideration is just part of the process. It's like saying, hey, politicians are involved, so of course politics is going to be part of the equation. And they pointed out that this is especially true in states where one party has a clear majority of voters. It's almost like the party in power sees it as their prerogative to use the redistricting process to solidify their advantage.
So a bit of a to the victor go the spoils argument.
Yeah, there's definitely a bit of that in there. And their second point was that this specific map, the one being challenged in court, had actually been put to the voters of Maryland in a referendum.
A referendum, so the people directly got to vote on it.
Exactly. And the map was approved by the voters. So the state was basically saying, look, the people had their say and they endorsed this map.
Okay, so those are some of the broad strokes of the case. Now let's really dig into the legal nitty-gritty. Why did the state of Maryland think the Supreme Court should have sided with them and overturned the lower court's decision? What were their big arguments?
Well, one of their central arguments revolved around the legal test that the lower court had used to evaluate this case. They argued that this test, called the single First Amendment retaliation test, simply didn't give the courts a clear and practical standard for deciding when political considerations in redistricting crossed the line into being unconstitutional. It's like they were saying, how are we supposed to apply this rule consistently? It's just too vague.
And that's a pretty big deal, right? If the courts don't have a clear standard to apply, it kind of becomes a judgment call, which can lead to a lot of inconsistency and potentially even bias.
Absolutely. And to bolster that point, they brought up this fundamental question. How can you truly separate politics from the process of drawing political maps? They argued that some level of partisan thinking is practically unavoidable. So their argument was, even if the map was drawn with some political motivations in mind, does that automatically make it unconstitutional?
So they were basically saying, hey, everyone does this to some extent, right?
Kind of. And they even went a step further by acknowledging that some Democratic legislators, and even one Republican, had specifically aimed for a 7-to-1 Democratic advantage in the state's congressional delegation when they were working on this map.
So they weren't exactly shying away from the fact that politics was involved.
Not at all. But their point was that this kind of maneuvering is just the reality of politics, especially in states where one party has a significant majority of voters. They argued that it's almost expected that the dominant party will use redistricting to try to maintain their control.
Okay, so that's a pretty bold argument. But they didn't stop there, did they?
Oh no, they had more ammunition. The state of Maryland also argued that the redrawing of the 6th District wasn't solely about gaining partisan advantage. They pointed to other factors that they claimed influenced the shape of the district, things that seemed unrelated to politics.
Like what?
Well, for example, they talked about the decision to remove a Chesapeake Bay crossing from the 1st Congressional District. This change, they argued, had a ripple effect on the boundaries of neighboring districts, including the 6th.
Interesting. So they were trying to paint a picture where it wasn't all about partisan politics, that other considerations were also at play. Now let's circle back to that referendum we talked about earlier. It seems like the state put a lot of weight on the fact that voters had approved the map.
Oh, absolutely. They really hammered that point home. They emphasized that the 2011 map wasn't just some backroom deal. It was put directly to the voters of Maryland, and it received a substantial amount of support. Over 1.5 million people voted in favor of it, including folks in counties that traditionally leaned Republican.
So they were using that popular vote as a shield, almost like a validation of the map.
Exactly. And to further strengthen their case, they cited a decision from a Maryland appellate court that upheld the wording on the ballot. So they were saying, look, not only did the voters approve this map, but the courts have already said that the ballot language was clear and fair.
That's a pretty powerful combination. You have the voters themselves endorsing the map, and you have the courts weighing in on the process. But I'm guessing the plaintiffs, the folks challenging the map, had a pretty strong counter-argument to that.
They absolutely did, and we'll get to that in a bit. But first, the state also tackled a very thorny legal issue. The question of whether partisan gerrymandering is something that courts should even be involved in. This gets into a whole debate about the separation of powers and whether the courts should be wading into political disputes.
Yeah, that's a big one. So what was the state's position on that?
Their stance was a bit nuanced. They didn't go so far as to say that courts never have a role to play in cases like this, but they strongly argued that the specific legal test used by the lower court in this case, the First Amendment retaliation test, was simply not the right tool for the job. It was too vague, too subjective, they claimed.
So they weren't necessarily saying that courts should never get involved, but they were definitely putting up some roadblocks.
Right. It's interesting to note that they strategically chose not to take a position on other potential legal tests for gerrymandering that were being debated at the time, especially those being discussed in the Rucho case. Their legal strategy was very focused on the specific flaws they saw in the lower court's reasoning.
It sounds like they were trying to pick their battles carefully, so they were hammering away at the idea that this particular legal test was inadequate, but they were also acknowledging that extreme partisan gerrymandering could pose a serious threat to our democracy.
That's right. They didn't shy away from acknowledging the potential problems of gerrymandering. They even said that it could undermine public confidence in elections and make people feel like their votes don't matter. But they kept circling back to the difficulty of creating a clear, objective, and practical standard for judges to apply in these cases. They argued that the line between acceptable political maneuvering and unconstitutional gerrymandering is often blurry and subjective.
So essentially, they were saying that it's a messy business and the courts might not be the best equipped to deal with that mess.
Precisely. And they brought up another interesting point. They argued that historically, the First Amendment, particularly the part about retaliation, hasn't been used to evaluate actions taken by legislatures. Their reasoning was that the very nature of legislating involves weighing different political viewpoints and making decisions that will inevitably have political consequences. It's inherent in the system.
That's a pretty compelling argument. You can't really have lawmakers ignoring the political implications of their actions, can you?
It's a tricky balance, right? But the state's point was that it's different from, say, an employer punishing an employee for their political views, which would be a clear-cut case of First Amendment retaliation.
So context matters. All right. What else did the state bring to the table?
Well, they also questioned just how effective this redistricting plan actually was in achieving the partisan outcome that the plaintiffs were alleging. They pointed out that even after the new map was in place, the 6th District still elected a Republican governor, Larry Hogan, in a subsequent election.
So they were basically saying, if this map is so rigged in favor of Democrats, how come a Republican still won?
Right. They used that example to argue that maybe the district wasn't as solidly Democratic as the plaintiffs were making it out to be. They also raised concerns about focusing too much on the intent behind the map. They argued that, in politics, partisan intentions are practically a given. They even referenced statements made by the governor at the time, Martin O'Malley, who had said that his goal was to ensure the redistricting plan followed all the legal requirements, while also hoping that it would lead to more Democrats being elected.
So they were acknowledging that there was a partisan hope, but arguing that it wasn't necessarily proof of any illegal or unconstitutional actions.
Exactly. It was a subtle but important distinction they were making. And they went on to argue that the court should be more focused on the actual impact of a map, the real-world burdens it places on voters, rather than trying to psychoanalyze the motivations of the people who drew it. They even drew a parallel to an earlier Supreme Court case, Crawford v. Marion County Board of Elections, which dealt with voter ID laws. In that case, the court focused on the practical burdens the law placed on voters, and the state was arguing for a similar approach here.
So less about reading minds and more about looking at real-world effects.
Precisely. And they also threw out the idea that other parts of the Constitution, like the Equal Protection Clause and certain aspects of the First Amendment, might offer a basis for challenging partisan gerrymandering, but they didn't really develop that argument in detail. It was more like they were leaving that door open for future cases.
Okay, kind of planting a seed for future legal battles. And finally, as is often the case in legal disputes, the state brought up the practical considerations of potentially having to redraw the map.
Right, the what if we actually have to fix this argument. They pointed out that the plaintiffs had waited a considerable amount of time to bring their challenge, and with the 2020 census just around the corner, forcing a redrawing of the map at that late stage would be disruptive and potentially unfair. They also reminded the court that Maryland law already required a new redistricting process after each census, so they were essentially saying, this map is going to be replaced soon anyway, so why bother with a costly redraw now?
A bit of a wait-and-see approach. All right, that gives us a solid understanding of the state's arguments. Now let's shift gears and look at the other side of the coin. Why did Benisek and the other plaintiffs believe the map was unconstitutional? What was their case?
Their argument boiled down to the idea that the 2011 redistricting in Maryland was a deliberate and calculated effort to dilute the voting power of Republican voters in the 6th District, purely based on their political beliefs. They argued that the goal was to make it significantly harder, if not impossible, for those voters to elect their preferred candidates. And they claimed that when such a blatant manipulation of the electoral process occurs, without any legitimate justification, the courts have a duty to step in and protect the fundamental rights of voters.
So they were really emphasizing the idea of intentional discrimination based on political affiliation.
Exactly. And they presented evidence to support their claim that this discrimination was real and had a significant impact on elections. They argued that effectively rigging the system to guarantee one party's victory, regardless of how the voters actually vote, strikes at the very heart of our democracy.
And as we've already touched on, the intent behind the map played a crucial role in their argument. They pointed to public statements from some of the legislators involved in the redistricting process, statements that seemed to indicate a clear desire to create a safe Democratic seat.
Right. And they also cited statistical evidence, using things like the Democratic Performance Index, to show that the map makers were well aware of the likely partisan outcome of their plan. They argued that it wasn't just some happy accident that the 6th District became so reliably Democratic, it was by design.
Okay, so they weren't buying the idea that this was just a coincidence or the result of neutral map making. Now, one of the state's arguments was that partisan considerations are just part of politics. How did the plaintiffs respond to that?
They countered that argument by drawing a distinction between what they called permissible partisan awareness and impermissible partisan intent. They acknowledged that it's practically impossible to completely remove politics from the redistricting process, but they argue that there's a big difference between being aware of the potential partisan consequences of your actions and intentionally designing a map to punish voters for their political views.
So they were acknowledging that a little bit of politics is unavoidable, but saying that it can't be the driving force behind the entire process.
Exactly. And they proposed a legal standard that focused on the practical burden that intentional discrimination, driven by partisan motives, places on voters. They argue that this burden is inherently connected to the durability of the gerrymander, meaning how long that unfair advantage is likely to last. The more durable the gerrymander, the more severe the harm to voters' rights.
Interesting. So they were trying to create a framework where courts could look at not just the intent, but also the lasting effects of these manipulated maps.
Right, and that was a key part of their argument. They wanted to shift the focus away from trying to read the minds of map makers and towards evaluating the tangible and enduring impact of those maps on voters.
Now, I'm curious, did they advocate for a system of proportional representation where the number of seats each party gets in Congress would directly reflect their share of the statewide vote?
No, they were very clear that they were not arguing for proportional representation. They actually stated explicitly that they believe the Constitution doesn't require that kind of outcome. Instead, their focus was on the fairness of the process itself. They wanted a system where maps were drawn in a way that didn't intentionally disadvantage voters based solely on their political affiliations.
So they were more concerned with making sure the process was fair, regardless of the specific outcome in terms of seats won or lost.
Exactly. They argued that the goal should be a neutral map, one created without the express purpose of manipulating electoral outcomes to benefit one party over another.
All right, so how did they address the elephant in the room, the referendum that had approved the map? The state leaned pretty heavily on that.
Well, the plaintiffs met that argument head on. They argued that a referendum, even a popular vote, simply cannot legitimize a map that is fundamentally unconstitutional in its design and intent.
So they were saying that the people can't vote away basic constitutional rights.
That was their central point. They drew a parallel to the issue of racial gerrymandering, arguing that a majority vote could never make it okay to create districts that intentionally discriminate against voters based on their race. And they apply that same logic to partisan gerrymandering, saying that the fundamental right to vote free from discrimination based on political beliefs is just as important and cannot be overridden by a popular vote.
That's a powerful analogy.
It was a very deliberate strategy on their part. They also hammered home the point that in this referendum, the voters weren't really being given a meaningful choice. They were simply voting on a map that had already been created by the legislature, a map that the plaintiffs argued was inherently flawed from the start. So they were saying that the referendum was more of a rubber stamp than a true exercise of the people's will.
Okay, so they were basically saying that the referendum process itself was tainted because the map it was based on was already unconstitutional.
Exactly. And they argued that the evidence of intentional partisan manipulation in this case was so overwhelming, so undeniable, that the referendum couldn't erase that taint.
So they were really pushing back against the idea that the referendum somehow validated the map. What about the First Amendment? We talked about how the state had some concerns about the way the lower court had applied it. What was the plaintiff's position on the First Amendment?
The plaintiffs argued forcefully that the First Amendment absolutely provides a solid legal foundation for challenging partisan gerrymandering. They pointed to a long line of Supreme Court cases dealing with issues like racial gerrymandering, vote dilution, restrictions on ballot access, and political patronage, all of which involve the First Amendment's protections of political speech and association.
So they were basically saying that the principles at stake in those earlier cases apply equally to the problem of partisan gerrymandering.
Precisely. They argue that the right to vote freely and effectively is a cornerstone of our democracy, and that when politicians manipulate electoral maps to punish voters for their political views, they are violating that fundamental right. And they believe the First Amendment gives the courts the power to step in and correct that injustice.
Now, I remember the state brought up the shape of the Sixth District and suggested that geography might have played a role in its rather unusual boundaries. How did the plaintiffs address that argument?
The plaintiffs didn't deny that geography is a factor in redistricting. After all, you have to draw a line somewhere. But they argued that in this case, geography simply couldn't explain the extreme partisan skew of the Sixth District and its bizarre, almost contorted shape. They pointed out that the district zigged and zagged in ways that seemed to defy any logical geographic or community-based boundaries.
So they were basically saying that the lines were drawn that way for one reason and one reason only, to create a safe Democratic seat.
Exactly. They argued that the mapmakers had prioritized partisan advantage over any legitimate geographical or community-based considerations.
Okay, and what about the state's point that Governor Hogan, a Republican, had managed to win an election in the 6th District even after the redistricting? Didn't that undermine the plaintiff's argument that the district was rigged in favor of Democrats?
The plaintiffs countered that argument by making a distinction between different types of elections. They argued that Hogan's victory was in a statewide race, a gubernatorial election, where factors beyond the specific congressional district lines can heavily influence the outcome. They called this type of election exogenous, meaning that it's influenced by factors external to the specific district.
So things like the overall political climate in the state, the popularity of the candidates, those sorts of things.
Right. But they contrasted that with congressional elections, which they called endemic, meaning that they're much more directly and significantly affected by the way the district lines are drawn. They argued that even though Hogan could win a statewide race, that didn't negate the fundamental and persistent disadvantage that Republican candidates faced in congressional elections within the heavily gerrymandered 6th District.
So they were basically saying that you can't just look at one isolated election result. You have to consider the overall pattern and the structural advantages or disadvantages created by the map.
Precisely.
Yeah.
And they made a broader point about the history of gerrymandering. They argue that it's a problem that's been plaguing our democracy for centuries, going all the way back to the early 1800s. But they also argued that in more recent times, the development of constitutional law, especially the way the First Amendment has been interpreted to apply to the states, has given the courts the tools they need to finally address this problem effectively.
So they were basically saying that the legal framework for tackling this issue has finally caught up with the problem itself.
Right. And they put their money where their mouth was. They actually presented their own alternative map for Maryland, a map that they claimed demonstrated that it was possible to take political considerations into account without resorting to the kind of extreme partisan manipulation that they saw in the 6th District.
So they were trying to show that there was a better way, a fairer way to draw the lines.
Exactly. They wanted to make it clear that the current map wasn't just the result of unavoidable political realities. It was a deliberate choice, and there were other, more equitable options available.
All right, we've heard both sides of the argument. Now it's time to put on our hypothetical robes and step into the 10th chair. If you were sitting on the Supreme Court weighing all these arguments, what would be your personal reflection on this case?
Taking on the role of that 10th justice, what really strikes me is the fundamental tension between the practical realities of politics and the enduring ideals of our democracy. It's undeniable that politics will always play a role in how our electoral districts are drawn. But at what point does that political influence cross the line and become a threat to the very legitimacy of our elections?
It's a tough question, and there's no easy answer.
Absolutely. While proving intent can be incredibly challenging, and some level of partisan consideration is probably unavoidable, I think the extent to which a redistricting plan demonstrably and durably disadvantages one group of voters solely because of their political beliefs raises very serious concerns about the health of our democracy. When a map is so obviously drawn with the primary goal of predetermining electoral outcomes, it really undermines the idea that voters should be choosing their representatives, not the other way around.
It's like the system is rigged, and that's a dangerous road to go down.
It is. And I think the role of a referendum in this case adds another layer of complexity. Can a popular vote truly validate a redistricting process that is arguably unconstitutional in its design and intent? While we value the will of the people in our democracy, there are certain fundamental rights, certain constitutional limits that can't simply be overridden by a majority vote. And that's where the analogy to racial gerrymandering, while a sensitive comparison, raises some valid points.
Right. It makes you question whether popular sovereignty, the idea that the people have the ultimate power, can be used to justify actions that might violate core constitutional principles.
It's a thorny issue. At the end of the day, I think Lomone v. Benisek really forces us to grapple with the delicate balance between the realities of politics and the ideals of our Constitution when it comes to drawing electoral maps.
Well said. This has been an incredibly insightful deep dive into a case that raises some fundamental questions about our democracy. We hope this breakdown has given you a better understanding of the arguments and the complexities of partisan gerrymandering.
And we hope it sparked some thoughts and questions of your own. What do you think about this case? What kind of standards should be used to evaluate these claims of partisan gerrymandering? We'd love to hear your perspective.
Thanks for joining us on this journey through the legal labyrinth. Stay tuned for more deep dives into pivotal Supreme Court cases. Until next time.